this assumes we now have a distribution onto the domestic individual that owns the C-Corp. And so what do we have there? Well, we have the foreign taxes shown there. Distribution, U.S. code doesn't have any tax at all on the GILTI amount. I'm just taking out the GILTI amount separately here. And then we have the dividend on the, I'm assuming 23.8%, using the 3.8 1411 tax. And you get a tax on the ultimate shareholder of a 202. And then what's the effective rate on this? If you add them up, the 150 foreign, from just the GILTI piece, and the 202 at the individual level, and you get 352, and that's about 35% of $1,000. So how is that anything close to 10%? Well, what's happened here, a couple things. You've got a foreign tax, which will show up in some of Maria's examples, and when you finally distribute out of a domestic C-Corp, you have yet another tax, even though the intervening domestic corp U.S. tax is completely offset, at least the GILTI piece of it, by foreign tax credit. So if you add the two things together, you can see how you get to 35%. You've got basically a 20-some% effectively on the dividend out to the individual, and you've got the 15% at the CFC level. So it's not necessarily 10.5. If we had zero foreign tax, then you would come out, at 10.5 at the C corporation level, and you would still have an additional tax being paid. There's a distribution. You don't get a GILTI deduction for E&P purposes, so the entire amount would come out subject to the 20% U.S. tax if you had zero tax at the foreign level. Okay, with that, I just want to point out in slide 82 is an example of these interrelated deductions, which we will not go through, but it's an illustration. And then beginning on slide 94 to 104, there's some examples of under the Tax Credit and Jobs Act of various alternative structures, greatly simplified. Gives you some idea how all of these rates that were presented on that original table that I talked about at the beginning of the webinar were computed. With that, we'll finally turn it over to Maria, who's been patiently waiting. So Maria, take it away.
Sure, so let me see if I can do that. So basically, I'm going to, I'm here, yeah. Is it me? Yes. So I'm basically going to speak about Section 962 election for GILTI inclusions, and I'm going to make a little introduction. So basically, when the Tax Act was enacted on December 22nd, 2017, after ruining our Christmas, we were left a little bit with surprises and what to tell our clients who had held CFCs for many years under the old regime, especially those clients with no sub-RF income that had operations abroad and never had to think about it. So out of the kind of the older sections of the code came the Section 962, who, to be very honest, I never had heard of. I was born in the 70s. And it was actually enacted in 1962. And it was basically an election that you, a shareholder, could make with respect to income of a CFC, so that the shareholder, the individual, would be taxed as a corporation. So the first slide just goes through, okay, so tax imposed on sub-RF inclusion of this individual, including GILTI, would be calculated under Section 11. So you're basically a corporation, and you get all the perks of the corporation. So we have some legislative history, and it was at the time a way for US individuals to be treated equally as US corporation with respect to their investments in foreign businesses. The reason it was really never used was because the corporate tax rate has been historically quite high. Before the Tax Act, it was at 35%. So as an individual, you wouldn't want to be taxed as a corporation and then deal with a double taxation. So in January 2018, literally, I've heard of firms calling the old partners or retired partners saying, did you ever use that? And how do we do it? And until recently, until the regs came out, we still had a lot of uncertainty on how it would work out. But it turns out it is now a major player in any restructuring you may envision for your individuals holding CFCs. So the application and the examples will make it a little bit clear is basically you take your GILTI income as an individual and you're going to be able to have foreign tax credits applied to the GILTI income as if you were a corporation, basically. It's the concept, it's that. So you basically will calculate the foreign tax credits under Section 960 for amounts that are subject to the 962 election. So that's, as I said, no different. That is if you were a C-Corp. Then the treatment of actual distributions, I still have a little bit of a difficult time to wrap my head around it, especially since, as we will see afterwards, the 962 election is an annual election, but normally your 92 ENP is the ENP of a foreign corporation that was included in the gross income of the taxpayer under 951, so that's your GILTI, for which a 962 election is in effect. And then you have the excludable 962 ENP, which is the tax paid by the taxpayer with respect to the 962 election in the prior year. And that, I think that you will have to go through the forms to really make those calcs. And then when the distribution is made to the taxpayer, the 962 ENP will always come after the regular previously taxed income, such as Subpart F, for example. So that the procedure is interesting to me. So it is 962 is available to individuals, to trusts, and to estates. You just make an election. It can be just attached to your tax return. The statement is quite simple. And the effect of the election is that all the CFCs owned by the taxpayer basically is as if they were owned by a C-Corp. You cannot pick and choose which CFC you make a 962 election for. You have to really, before you make the election, do those calculations. Does it make sense? As it was often said before, this new tax act is the spreadsheet tax act. So if you're not good with spreadsheets, you should get a tutorial on that, because you have to do quite a bit of calculations and projections, how it's going to look in the final tax return. Now, you can't revoke the election, so without the approval of the commissioner, which that would be in effect if you want to amend your return, you could be really in a bound there. So the recent development that we've seen is, since the election is only available to individuals, can it be made if the CFC is owned through an S-Corp or partnership? And that is yes, but it's made by the individual. It's not made at the partnership or the S-Corp level. Is the 250 deduction for GILTI inclusion available for 962? Up until the regulation, I was the negative Nancy, and I was doing my projections without the 250 deduction. I was wrong, and I'm very happy that I was wrong. And then our subsequent distributions qualified dividends, if distributed from the CFC to the shareholder, from CFCs that are located in a non-treaty jurisdiction. And that my answer we're going to see with the Smith case is that it shouldn't be, and I'll explain why. And that's where the examples will come in handy when you want to see what kind of restructure you're going to do for your clients.